Hey everyone, today we're going to talk about causation in the context of negligence. The damage suffered by the plaintiff, the person who is suing, must have been caused by the defendant's breach of his duty of care and not due to anything else. Also, the damage suffered by the plaintiff as a result of the breach of the duty of care must not be too remote. In other words, the plaintiff's breach of the duty of care caused the injury to the defendants. The breach caused the injury to the defendants. That's called causation. In other words, the plaintiff caused the damage and nothing else. If the chain of events causing the plaintiff's loss is interrupted by an external factor that was not reasonably foreseeable, for example, the defendant's breach caused damage to the defendant, but then something else intervene. Then something else happened to the defendant after the damage was caused, and so he suffered further damage. Any damage caused after the intervening incident might be considered as too remote and not related to the original breach of duty. If so, the defendant may not be held liable for the plaintiff's losses after the intervening act. Let me give you an example. If the plaintiff slipped on a wet floor and the plaintiff fell and broke his finger as a result of the defendant's failure to keep the floor dry and safe for walking. So he would have a claim against the building management, for failing to keep the floor dry and safe for walking. While the plaintiff was on the floor and someone accidentally kicked the cupboard and the cupboard fell on the plaintiff's finger while he was on the floor, then the defendant may not be held liable because there was an intervening event. The test for causation is the but-for test. Therefore, the defendant will be liable to the plaintiff only if the damage would not have occurred but for his negligence. This principle was laid down in the case of Yeo Peng Hock and Pai Lili. When a tort, a civil wrong like negligence, is followed by a natural event which wipes out the physical effects of the tort, then the defendant's liability ceases at the date when the supervening event manifests itself. This was laid down in the English case of Jopling and Associated Diaries. If this were not so, then the defendant would be liable for damage which would have occurred naturally anyway due to the vicissitudes of life. This is called the Vicissitudes Principle. Let me give you an example. If the defendant, by his own negligence, caused the plaintiff to suffer a broken spine, and it was later found that the plaintiff suffered from a natural pre-existing spinal cord condition, deterioration of the spine, which would have caused him to be bedridden, for example. A defendant is potentially liable for all foreseeable consequences of his negligence. However, the chain of causation between the defendant's negligence and the damage ultimately suffered by the plaintiff can be broken by a new intervening act. This is called the novus actus interveniens. This intervening act can be by the plaintiff himself or a third party, but it breaks the chain of causation, and the defendant will not be liable for the damage suffered after the intervening act. This was laid down in the Singapore case of Jet Holding and Cooper. I should also mention that a defendant who has already negligently caused damage to the plaintiff or who has negligently exposed the plaintiff to the risk of damage will not be liable for any damage which the plaintiff subsequently sustains due to his own unreasonable response to the situation in which the defendant had placed him. This principle was laid down in McHugh and Holland and Hannon. So for example, if the defendant, while out hunting, accidentally shoots the plaintiff in the hand, and then instead of going to the hospital, the plaintiff goes home, tries to take out the bullet and bandages himself, and then there was an infection, and then he had to have his whole arm, the infection spread to the arm, and he had to have the whole arm amputated. So the defendant would not be fully liable to the plaintiff for the amputated arm because the plaintiff's behavior of trying to take out the bullet himself and bandaging himself, it was not reasonable. He should have gone to the hospital, and therefore the defendant should not be liable for the amputation of the damage caused for the amputation to the whole arm. So thanks for watching this video on